Every year, Missouri publishes a document that quietly answers one of the most important constitutional questions in this state. It's not a press release. It's not an opinion. It's not an activist report. It's the state's own traffic stop data, and almost nobody reads it. I'm a criminal defense attorney in Missouri, and today I want to talk to you about what this report actually shows and why, under the Constitution, pretending that it's meaningless is no longer defensible. Because when the same outcomes repeat year after year, they stop becoming isolated data points. They start becoming patterns, and patterns matter. If racial profiling is illegal, then why do Missouri traffic stop reports show these same racial gaps every single year? This isn't a rumor. This isn't social media. Missouri law requires that police departments report traffic stops by race, the reason for the stop, whether a search occurred, and how the stop ended. And year after year, the results come back the same. Certain drivers are stopped more than others, statewide and locally. When the same disparities persist over time, the Constitution doesn't treat that as a coincidence. It treats it as something that demands scrutiny. And here's the constitutional problem most people miss. The harm isn't just what happens during the stop. It's how often the stop happens. Why do stop rates matter more than searches or arrests? Because everything in policing starts with a stop. A search can't happen without a stop. A citation can't happen without a stop. An arrest cannot happen without a stop. If one group experiences significantly more stops, that group experiences more police contact, more questioning, more commands, more escalation opportunities, and more chances for something to go wrong. You don't need a confession to recognize that harm. But under the Constitution, equal protection claims turn on discriminatory purpose, not just impact. That's an important distinction. Disparities alone don't automatically equal a constitutional violation. Courts are clear about that. But persistent disparities aren't meaningless either. Courts repeatedly say that statistics are the beginning of the assessment, not the end. They are evidence that can justify closer scrutiny, especially combined with how discretion is exercised on the street. This is where people usually respond, but pretextual stops are legal. That's true, but only to a point. Under Supreme Court precedent, if an officer observes a traffic violation, the stop itself is lawful, even if the officer's motivation is something else. That's the Fourth Amendment analysis. But the Supreme Court was explicit about something else. Racially discriminatory enforcement violates the Equal Protection Clause. And that analysis is not about one stop. It's about patterns. Did the Supreme Court legalize racial profiling? No. What the court did was separate two constitutional questions. The Fourth Amendment asks whether there was objective justification for the stop. The Equal Protection Clause asks whether enforcement is being applied unequally based on race. Missouri keeps acting like the first question is the only one that matters. It isn't. That's why courts repeatedly say that challenges to over-policing don't turn on whether a single stop was technically justified. They turn on how discretion is applied across communities over time. That's where the Constitution steps in. And that's also why Missouri law itself addresses racial profiling. State law requires agencies to adopt written policies prohibiting race-based traffic stops, to collect data, to review patterns, and to intervene when disparities appear. That wasn't accidental. The legislator recognized something critical. Patterns of enforcement can raise constitutional concerns, even when individual actions appear lawful in isolation. Now let's talk about searches, because this is where departments often try to change the subject. Search rates have shifted in recent years. Departments like pointing to that as proof of reform. But the real question is this: when certain drivers are searched more often, are police actually finding more contraband? Missouri's own reporting shows that higher search rates do not consistently produce better results. More searches without better outcomes is not evidence-based policing. It's unequal discretion. And discretion is exactly where constitutional violations hide. Discretion isn't loud. Discretion doesn't announce itself. Discretion only shows up when you measure it. Missouri measures it every year. So what does consistent over-policing mean for real people? It means the same drivers get stopped repeatedly. The same neighborhoods absorb the contact. The same residents experience routine interactions that stop feeling routine when they never stop happening. This isn't just inconvenience. Repeated police contact changes behavior. It changes how people drive. It changes how people move through their own neighborhoods. And the Constitution does not ignore patterns just because they've become normalized. Nowhere is this clearer than at the local level. In places like St. Louis City and County, the disparities are not abstract. They are lived. They exist under laws that already prohibit racial profiling. So when the same disparities appear year after year, the question isn't if Missouri knows this is happening. The state of Missouri knows. The real question is why nothing changes. Because data without enforcement isn't reform. Missouri measures the problem. Missouri publishes the report. And then Missouri moves on. That's not accountability. That's avoidance. We've already seen what happens when patterns are finally taken seriously. The Department of Justice didn't investigate Ferguson because of one bad stop. They investigated because the same enforcement practices kept hitting the same people over and over, creating systematic constitutional harm. Courts recognize that systems, not just individuals, can violate constitutional rights. That's why pattern and practice investigations exist. That's why municipal liability exists. And that's why over-policing doesn't disappear just because individual officers follow the checklist. So let's answer the final question directly. Can policing be unconstitutional even if every stop is technically legal? Yes, because constitutional harm isn't always loud. Sometimes it looks like repetition. Sometimes it looks like paperwork. Sometimes it looks like these same communities carrying the burden of enforcement year after year with no meaningful intervention. That's exactly what the Constitution is meant to prevent. This isn't anti-police. It's pro-constitutional policing. Enforcing traffic laws isn't the issue. Disproportionate, repeated enforcement is. If you live in Missouri, you can review your department's traffic stop data yourself. Compare stop patterns, not just arrests, and ask why the same gaps never close.